Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. And whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Hey, good morning, everyone. Today is Tuesday at 10 a.m. Pacific here on the Bottled Business Sense Show. Welcome to our episode. And if you're watching from Facebook or YouTube, remember to like us. You can also find us on Twitter, LinkedIn. So with that, I'm Rick Moscoso, one of your co-hosts. And on the other side of the ocean is my co-host, Mr. Bill Bernard. How are you doing?
Yes. How are you, sir? Good to see you. Good to see everybody. And we're going to talk today about an issue that I think is near and dear to a lot of people's heart, and that is the actual liability benefits and restrictions that are inherent in the formation of an LLC. And I'm going to talk about an LLC in general, and then I'm going to talk about an LLC with respect to California. And generally speaking, we know with business entities, and again, today we're concentrating on LLCs, the main reason to form an LLC, of course, is to avoid personal liability for debts incurred or liabilities that may come about as a result of the functioning of the business under the LLC umbrella. So a couple of things that you need to keep in mind is that if you form an LLC to operate your business and you don't personally guarantee or promise to guarantee the payment of debts as an individual, you ordinarily never be personally liable for an LLC's debts, ordinarily. A couple of caveats there. Many creditors, when they do business with an LLC, will want you to personally guarantee any business loans, for example, because they know that they can't come after you personally if you do something within the course and scope of the LLC business that isn't grossly negligent or intentional conduct. And so consequently, they'll want you to personally guarantee these loans. That might be a problem for you, and you're going to have to find a way to get around that by maybe seeking some business with other loan institutions that might not be as wary of the LLC formation. So I wanted to make sure you keep that in mind, and we'll also talk about how the LLC can be broken if you don't do the proper things to upkeep it. But let's talk a little bit about personal liability for actions of LLC co-owners. So you're in an LLC with more than one person. The LLC will protect owners from personal liability for any wrongdoing committed by co-owners or employees of the LLC during the course of business. The LLC's money or property can be taken by creditors to satisfy a judgment against the LLC, but the LLC owners are not personally liable. So they're not going to come after your house or your car. The owner or employee who committed an act might also, however, be personally liable for his or her own actions under certain conditions, but the other co-owners of the LLC will not be. So keep in mind that distinction. You've got multiple member LLC. One guy commits a seriously negligent act during the course and scope of the business. Only that LLC member's business portion will be held accountable, and potentially his personal assets as well, under certain conditions that I'm going to describe, but not the rest of the LLC members. They're protected. So let's use an example. Let's take a guy. Let's take Rick. Okay, Rick, my co-host, is an employee of a bakery company, and the bakery is an LLC, and he's making deliveries one day, and he runs over a brain surgeon in the crosswalk of a street. So Rick, being Rick, he's driving while he's intoxicated, and the bakery is sued and found liable for the negligence of Rick. All of the bakery's business, property, assets, money, and insurance can be used to pay the judgment awarded against the surgeon's heirs. Okay? However, the other LLC owners in business with Rick are not personally liable for the LLC's employees' actions, Rick's actions, so those personal assets of the other LLC owners cannot be reached. Let's now talk about personal liability when you own an LLC under the example that we gave for Rick. So LLC owners can be personally held liable. The LLC can be invaded, so to speak, when the individual is personally and directly responsible for injuring someone during the course of the business as a result of their own negligence. And in this case, Rick was clearly negligent by hitting the bottle so early in the morning before he made this delivery from the bakery. You can be personally liable if you fail to deposit taxes withheld from an employee's wages. Okay, there's an overlap in employment law there. You can be personally liable if you intentionally do something that's fraudulent, illegal, or reckless during the course of the business relationship. We all know that fraudulent acts pierce the corporate veil. And you can be personally liable if you treat the LLC as an extension of your personal affairs. You commingle funds. You really don't have an LLC. You're just using an LLC name in order to hopefully avoid personal liability. It's a fraud in a different way, so to speak. So courts can then invade the LLC and come after your personal assets under those conditions. So this is why, let's go back to the first one, where you're personally and directly injure someone during the course of the business. This is why LLC and their owners should always have liability insurance, because the liability insurance not only covers business debts that you're sued for, or you may be sued for, but liability insurance can also be used to cover other negligent acts that might cause you to be personally liable. But usually, remember, liability insurance will not cover intentional acts. So you're making that delivery in the morning, and Rick decides to rob a bank, and he accidentally bonks somebody with his gun. Not accidentally, but intentionally bonks somebody with his gun. The guard knocks him out so he can steal the money. You're not going to, the insurance is not going to cover an act like that. But you get what I mean. You do an intentional act, most any insurance policy is not going to cover intentional torts, much less intentional criminal acts. Let's talk about the LLC's liability for members' personal debts. So now you have a debt. An LLC's money or property cannot be taken by creditors of an LLC's owner to satisfy the personal debts against the owner. We've been talking about this a little bit. One of the LLC members has an issue, got a personal debt. You can't take that LLC's portion of the business to satisfy that personal debt. However, you can potentially get what's called a charging order. You can go to court and get a court to order that the LLC pay the creditor the money due by using the money that is being paid to the individual member who's responsible. He gets a salary from the LLC. That charging order can say whenever that money is dispersed to that member, that money and only that money can be used to satisfy the judgment that's against that personal member. You can also get a court order for closing on that owner-debtor's LLC ownership, and you can get a court order that the LLC be dissolved under certain specific situations. Let's talk a little bit more about this category. If the LLC interest is foreclosed upon, the foreclosing creditor becomes the permanent owner of all of the debtor member's financial rights, including the right to receive money from the LLC. That is that debtor's salary, right? This creditor now receives the salaries. All states allow creditors to obtain a charging order against an LLC owner's interest at the present time. Now, what's interesting is if this guy takes over and gets this charging order, or if he now forecloses upon the LLC's members' portion of the business, he gets the money that the member would have otherwise gotten to help pay the debt or the judgment that the creditor got, but he can't participate in the LLC and run the LLC. And so more than likely there's going to be an issue there where the LLC members come to some resolution to either dissolve or form a new LLC. So let's talk about single member LLCs a little bit before we get into the specifics about California LLCs. The rationale for limiting an LLC member's personal creditor's remedies that we've just been talking about to a charging order situation is there to protect other LLC members from having to share management of their LLC with an outside creditor. There are no other LLC members to protect, however, in a single LLC membership, right? You form your own LLC. There's no other members there but you. So some states have found that single member LLCs are not entitled to the charging order protection. Okay. The rationale being that limiting a creditor's remedies to a charging order doesn't apply because there's no other member involved. So you don't need to be protected as the secondary member who's not responsible for the debt and the judgment that the creditor got. So why do you need a charging order protection to begin with? Well, let's piggyback on that now and go into California LLCs. California allows creditors of LLC members to obtain a charging order to collect on a judgment obtained against an LLC member. A charging order, again, directs the LLC to pay the creditor any distributions of income or profit that would otherwise be distributed to the LLC member or debtor. Like most states, creditors with a charging order in California only obtain the owner-debtor's financial rights and cannot participate in the LLC's management. We've talked about that. It's worth repeating. Now, since a creditor with a charging order cannot participate in the LLC's management, it cannot order the LLC to make a distribution or that LLC to be sold to pay off the debt. So now you've got a charging order against a member of the LLC, and that creditor who's got that judgment has a right to receive any money distributed to that LLC member, right? What if the LLC says, hey, we're not going to distribute any money to that member? And the LLC votes not to do that, assuming that provision is provided for in an operating agreement. Well, now the creditor can't get access to the funds that the debtor LLC member would have ordinarily received as a salary, or a distribution of some kind. So, although a charging order may be a weak remedy under those circumstances for a creditor, it is not necessarily toothless, because a charging order can make it difficult or impossible for an LLC owner, debtor, or other persons, if any, to take money out of the LLC business without having to pay the judgment creditor first, because you're going to be kind of hamstrung to say, well, we're not going to give any distribution to the debtor member of the LLC, so the creditor can't obtain that money, but yet we're going to give it to the rest of the members. You're going to probably have to say nobody gets any, and then you're kind of playing hit and miss here. You're either trying to settle this debt for a lesser amount with the creditor judgment holder, or you're trying to say, hey, we're going to make life difficult for you for a while to where you're not going to follow up on this charging order. Or maybe you decide, hey, it's not even worth going after the charging order. I know these members in this LLC, they're going to ride it out. They've got money, they can handle it. They're going to press me. So I'm not going to waste my money going after a charging order and sitting around waiting to get paid. I'm just going to cut my losses and bug out of here. So all of these things come into play. Let's talk a little bit about foreclosure. Again, under California, it allows a creditor to foreclose on the debtor-creditor's LLC interest. And under this procedure, a court orders that the debtor member's financial rights in the LLC be sold. The buyer at the foreclosure sale becomes the permanent owner, again, including the right to receive money and any assets that he would be owed under the judgment if the LLC is dissolved. But again, he or she may not participate in the management of the LLC, the running of the business. So foreclosure can end up being an expensive and difficult undertaking. Often, as I said before, the LLC members will attempt to settle this kind of a situation for a lesser value on the dollar if possible. California does not permit personal creditors of an LLC member to have a court order that the LLC be dissolved and that its assets sold to pay off to the creditor. So now we've talked about dissolution, but is specifically with regard to California, that state does not permit personal creditors of an LLC member to get a court order to have the LLC dissolved. So again, your best mode of operation there is when you have a creditor coming after a debtor member of the LLC, the creditor gets a judgment, try to settle the thing out because waiting it out may not work, and you're not available to get a dissolution of the LLC in California, although you may try to foreclose on that debtor member's rights. So you have that foreclosure possibility, and you also have the charging order possibility. Okay, single member LLCs now in California. As a result of court decisions, California is not one of the states that makes a distinction between multi-member and single-member LLCs, because some states provide less protection because, again, you only have a single member. Why do you need that extra protection? There are no other members to protect. But California does allow that extra protection, and it. Let me give an example. For example, where a California single-member LLC does business or owns property in another state, that state's LLC laws provide, legal remedies, and they might be ignored depending upon how the court decides where the bulk of the business is being done, what agreements might have been signed that indicate what applicable law is to be followed. So you need to be aware of this stuff when you form an LLC in another state, or when you form an LLC in California and intend to do business in another state. So let's briefly talk about the formation of an LLC in another state. You do not have to form your LLC in California, even if it is a state where you live or do business. As a general rule, the formation state's LLC law will govern, although you might enter into an agreement that says otherwise. Nevertheless, doing so will increase your costs because you have to pay the fees to form your LLC in the other state, plus the fees to register and do business in California. And we're talking fees, obviously, that are paid to the Secretary of State. And doing business in another state may be as simple as keeping a checking account in a bank in that state. That could be considered doing business, and therefore make you susceptible to pay the yearly fees to the Secretary of State in that particular state. Everybody has always talked about this. I thought I'd bring it up here. Nevada, Delaware, Wyoming are very debtor-friendly states in terms of debtor-friendly LLC laws. But there is no guarantee that California or other courts, for that matter, in other states will always apply the law of the state where you form the LLC. Again, there is no definitive answer. It's a complex legal issue depending on the specific facts of your situation. And therefore, you need to consult with an experienced business lawyer should you get into trouble. But of course, it wouldn't hurt to prepare and make sure you understand what applicable law should apply so you can make that argument with your lawyer if and when a problem arises, if and when litigation arises. Let's talk about an issue near and dear to my heart before we close the show, which is umbrella insurance, which I believe is a no-brainer. Now, let me tell you briefly, umbrella insurance is built to be there for excess claims that might exceed your regular insurance policy. It won't trigger the payment of benefits until the primary policy has been exhausted. Simply stated, the umbrella policy doesn't cover the gaps in standard insurance coverage. It rather covers claims that might exceed that standard insurance coverage. So you have a policy for $300,000. You have an umbrella insurance policy for $1 million. If the claim is above $300,000, the umbrella policy kicks in. But if there's exclusions to the $300,000 policy, that umbrella policy will not apply, typically speaking. So ask yourself this as you think about the show and what we've talked about. You must think about liabilities that don't involve your business. Here's what I mean by that. Think of a lawsuit or a cause of action that could take away your business. This is liability that isn't created by your business, but by your personal actions. This is the exposure created outside of your business that could allow a creditor to take your business away from you. So here's the distinction. And you know, Rick, we've talked about this on many shows. This is a big distinction. So you have a business entity, you have an LLC. To recap, why, Rick? In order to do what? To protect your what?
To protect your personal assets.
That's right. Now you have your LLC or your business entity to what? Cover your business debts, right? Should you be sued? Now, what happens if you're doing, let's flip the coin. What happens if you're doing something on your own, on your personal time, and now you hit this brain surgeon in the crosswalk, and you're drunk as a skunk, and now there's this multi-million-dollar judgment against you. You can have your business taken away from you because your business is also a part of your assets. So this has nothing to do with protecting your personal assets. This is a situation where your personal assets are directly exposed because you did something personally on your own time, not in the course and scope of your business. So the LLC protection doesn't come into play. It's apples and oranges. Now we're talking about somebody getting a judgment against you for something you did personally. Your house is an asset, your car is an asset, your business is an asset. So your business can be taken from you. You need to have great liability insurance, and you need to have an umbrella policy for these reasons. Umbrella insurance can be the one most affordable form of asset protection that you engage in, and umbrella policies are not expensive. You can get them anywhere from $200 to $400 bucks a year. Maybe a little more in some places, and you can get a coverage of $1 million or as much as you want. So these are things you need to think about, and I wanted to bring this up as a tail end of this LLC discussion because you need to understand the distinction between personal debt and business debt, but you also need to understand what's exposed under what conditions. Your business assets are not exposed if you do the right thing and maintain your company. When your business assets are exposed, rather, when you do something in the course and scope of your business, your personal assets are not, as long as you maintain your company. However, your business assets can be exposed as an asset that you own if you do something personally that's wrong and that you have a judgment against you and that's imposed upon you personally. I hope this makes sense. I hope you understand what umbrella insurance is, and I hope you keep in mind the various tools and methods that you can use to protect yourself. This is really a kind of a business, kind of a / asset protection show. I hope it's been generally helpful for you. Remember, this is not legal advice. These are general principles that you need to think about and speak to your own lawyer about as it concerns a specific situation or scenario that your business or your everyday business life may be involved in. Okay, so you need to keep these things in mind. So I hope that's been helpful, Rick.
Well, as always, Bill, thank you for sharing your expertise. Appreciate all the listeners out there. There's a number of people that are watching right now, watching us here on YouTube. So remember, before you leave, to subscribe to our channel. There's a boatload of episodes. I was just looking back at when we first started, and I think within that first year we did quite a few. One every week we were doing it, and now. Just because of all the things that we're doing, we are broadcasting. We try and broadcast twice a month. Sometimes it's every other month. Sometimes a little bit longer, depending upon how many weeks there are. So make sure to subscribe on YouTube. You'll get a notification when we're on, as well as Facebook if you're watching the replay there. And if you have any questions in regard to today's topic, please reach out to Bill at the email or number below, and he'll be happy to strike up a discussion with you to see how and if he can help. So,
yeah, and understand, this business platform that I formed for this show, which is the triumvirate. I don't know if I pronounced that correctly.
Triumvirate. That's
triumph. No, it's a trifecta. Let's do that. Okay. Of business law, which incorporates estate planning and employment law and asset protection, or the formation of a business entity. Those three things are really in my view, candidly, the key to enjoying your life. The three keys to really making sure your life is in order, because it not only involves protecting your livelihood, but protecting yourself against employee claims, protecting your employees and making them understand what their obligations are, and then protecting your assets by way of leaving them to the people that you want to leave those assets to by way of an estate plan. If you cover those three bases in your everyday life, you're going to get through life pretty well, in my opinion, and you're going to enjoy your life, especially. These are critical areas, and that's why I chose them, and that's why I enjoy doing them so much, because every one of these areas helps people and helps small businesses. So keep this stuff in mind. Take this stuff to heart. Incorporate it, so to speak. No pun intended. Go get a lawyer and make sure you understand what you're doing and why you're doing it. Set goals. Have a business plan, and protect yourself. Because you don't want to leave it to somebody else other than your counsel to stand up for you. Nobody else is going to do that. And as long as you're not entertaining any criminal activity, then you're going to be fine, because these three areas will give you the foundation that you need to really enjoy your life. I really, truly mean that. So anyway, I hope that's been good. Contact me by email if you have questions. I prefer that rather than phone calls. If you're interested in becoming a client and you really want to do something, then fine, give me a call. But I'd rather not receive phone calls just for quick questions. I'd rather receive emails for that. Understanding that when you do that sort of thing, you're always going to get general advice, because this isn't an attorney-client relationship until we enter into a retainer agreement, and until there is some remuneration exchanged. Okay. So with that, Rick, I'll leave it up to you to close and tell people where they can get a hold of us. And I hope everybody has a great, prosperous week.
Excellent. Thanks again, Bill, for sharing your expertise. Folks, you can always find us on Facebook, Twitter, Instagram, and YouTube. Remember to like us on Facebook and subscribe to our channel on YouTube, so you do get the notifications when we do broadcast. And like I said, we broadcast every other week on a regular basis. Usually, if there's any changes, we'll let you know. But go ahead and subscribe. You'll get notifications for our next episode. So with that, thanks again, Bill. We'll see everyone in a couple of weeks.
You got it.
and everyone have a profitable day.
Take care, everybody.